We will dive into the Appellate Court case, as well as the controversial decision about bail for the defendants. Come along with us as we finish the Blood Breathitt County Feud. All aboard the Kentucky-Tennessee Living Time Machine. Please fasten your seatbelts and keep your arms and legs inside of the vehicle at all times. But to get going, we need your help. We still need to fire up that time machine to transport us. Please help us by clicking on the like, subscribe, and bell notification buttons down below. Not only does this fire up the time machine for our flight back in time, but it convinces the YouTube algorithm that we need a bigger vehicle to reach more people who love history as much as you do. Now, back to our story. The Hargis case continues. To say that the Commonwealth attorneys were not happy was an understatement. They felt that Judge Parker threw the case for the defendant. A term that is no longer used is, quote, passed upon, unquote, and you will hear it a lot in these appeals processes of the case. It simply means that the attorneys are exercising their right for the case to be reviewed by the Appellate Court concerning the lower court's decisions. In other words, Judge Watts Parker's jury instructions were not as the Commonwealth felt was fair according to the indictments, and they wanted the testimonies from those in Wolfe and Leslie counties that were denied to be let into the case record. The Interior Journal reports, May 16, 1905, quote, Commonwealth's Attorney Allen of Lexington will ask the Court of Appeals to pass upon the legality of Judge Parker's instructions to the jury in the James Hargis case, and also upon the right to reject certain testimony which was not allowed, unquote. This was very important, as the decision on whether or not to retry Judge James Hargis for the crime of conspiracy to murder hung in the balance. We get more details of this from the Mount Sterling Advocate, May 17, 1905. Quote, Colonel Allen asked for a higher tribunal to pass upon instructions given by Judge Parker in the case against Judge James Hargis. On Thursday, the Commonwealth in the James Hargis case, represented by John R. Allen, appealed from the decision of the Fayette Circuit Court. The higher court will be asked to pass upon the legality of the instructions given in the case. This proceeding is seldom resorted to by the Commonwealth. It is in accordance with the provisions of the Code, which gives the Commonwealth the right, in cases of mistrials, to have the Court of Appeals pass upon the instructions and upon the competency of testimony admitted or rejected by the trial judge. The Commonwealth, in asking for this appeal, which was granted by Judge Parker, realizes the odds against the conviction in any of the cases under the instructions. It announces that it desires to have these serious legal questions decided by the higher court so that further time and labor and expense of mistrials may be avoided. If the instructions given by Judge Parker are held to be valid, it is probable that the cases will be remanded to the grand jury and another indictment drawn, which will permit an instruction covering accessory before the fact, unquote. So, it depended upon who the appeals court agreed with on this decision as to what would happen next to the case. If they agreed with the Commonwealth attorneys, then the actions of Judge Parker could not be done in future cases, and it would help juries to make better decisions and relieve them of being deadlocked. If the appeals court decided to agree with Judge Parker, then the Commonwealth would have to take its case back to a grand jury and have another indictment issued for the case. There were other cases behind this one for the same charge of conspiracy, and how the appellate court would rule would affect those cases under the current indictments and could lead to the Commonwealth taking each case before a grand jury for a new indictment. Because of this, we will see what happens to their cases next. According to the Daily Public Ledger, the cases of James Hargis, Alex H. Hargis, and Ed Callahan, charged with conspiracy in the murder of James Cockrill, and docketed in the Fayette County Circuit Court, which opened Monday. will probably be continued, pending a ruling of the Court of Appeals in the James Hargis case, unquote. So, now several cases were just tossed up into the air because of the actions of Judge Parker. The Commonwealth now had a decision to make. Either they had to let the defendants go until the appeals court ruled on this matter, or try to go ahead and roll the dice and try their cases now. Bail granted. Judge Parker basically told the Commonwealth attorneys to try the cases or to let them go with bail. Going back to the Mount Sterling Advocate, May 17, 1905. Quote, other cases passed. The cases against the other defendants were called Thursday and passed until Tuesday. Judge Parker indicated that in the event the cases were not tried, he would grant the other two defendants bail. The Commonwealth announced that it would elect to try Edward Callahan next, unquote. Basically, Judge Parker just put the Commonwealth on a clock. They could not hold the defendants in jail forever. They had the right to be tried in a timely manner or set free on bail. Instead of waiting on the Appellate Court, the Commonwealth decided to go ahead with its other cases. But there is now a question about Judge James Hargis. Would he be set free, placed on bail, or remain in jail because the jury could not make a decision? In the article found in the Mount Vernon Signal, May 12, 1905, quote, in the state, Judge Watts Parker of the Fayette Circuit Court Monday admitted James Hargis to bail in the sum of $25,000. The bond was signed by Floyd Day and J.C.M. Day, wealthy lumber merchants of Jackson, and M.C. Courtney and John M. Stevenson of Winchester, unquote. The first to go out on bail because his case had been tried and the jury could not make a decision on the matter was Judge James Hargis. It could take years for the appellate court to make a decision on the case. And so, Judge Parker set his bail, and after it was paid, released him. Now, $25,000 back then was not the same as today. As of August 2024, the conversion is $1 in 1905 is the equivalent to $35.70 in purchasing power today. So the bond set for Hargis could be read as a value of $893,579.55. That would be a huge chunk of change to come up with all at once today. That is why Hargis went to both Days, Courtney, and Stevenson for help with the money needed to make bond. An agreement had to be reached concerning the cases of Elbert Hargis and Sheriff Edward Callahan, because their cases also hinged upon the verdict of the appellate court. According to the Interior Journal, May 16, 1905, quote, as the result of an agreement between counsel for defense and prosecution, Judge Parker at Lexington admitted Elbert Hargis and Ed Callahan at Breathitt County to bail in the sum of $10,000 each and continued their cases to the fall term of the Fayette Circuit Court, unquote. As we have already explained how the inflation calculator works, $10,000 in 1905 would be worth $357,431.82 in today's currency. And now those cases would be heard in the fall term of the year of 1905. We searched for the appellate court ruling upon this matter. We did find that a year after this case was put before them, the appellate court still had not ruled in the cases, and that Colonel Allen stated that they would continue on forever if needed. We can surmise that these cases were dismissed in 1908, when the first defendant, Judge James Hargis, and the second defendant, Jesse Spicer, were both killed. We can reasonably give this guess because the cases against the other defendants were dropped after the Hargis death. According to the Interior Journal, October 9, 1908, quote, in the Fayette Circuit Court, the cases of Alex Hargis, Elbert Hargis, Ed Callahan, and Jesse Spicer, charged with complicity in the assassination of Town Marshal James Cockrill at Jackson 5 years ago, which had been on the docket for 2 years, were ordered dismissed and stricken from the docket." Unquote. This is the last trial we will cover in the Blood Breathitt County series. There were several other trials in several different counties, and all of them resulted without a conviction for conspiracy. Only those that could be found with a smoking gun in their hand were found guilty of the crimes. The rest of the faction, rightly or wrongly, were never convicted. And now, it leaves open the question, were they guilty or innocent of the crimes of conspiracy in the murders of Cox, Markram, and Cockrill? What happened to the Feudist? While there are many people involved in this feud, we will go over what happened to the main characters that were charged with conspiracy to murder Cox, Cockrill, and Markham. All source information about them is found in the description box under websites below. Judge James Henderson Hargis would be shot and killed by his own son Beach Hargis on February 6, 1908. The two men had an argument in the Hargis General Store when the shooting occurred. Several more trials for conspiracy to murder would take place against Hargis for the murders of Cox, Cockrill, and Markham in several counties, of which he would be acquitted of all charges against him. However, the Markham damage case of the appeals court did rule with Widow Markham, and Hargis was found liable and had to pay her damages. Judge Hargis was 45 years old at the time of his death. Kentucky State Senator Alexander Hamilton Hargis would die in Lexington, Kentucky on April 30th, 1943, at the age of 83 years old. He would be acquitted of all charges against him. Elbert S. Hargis would die in Fayette County, Kentucky on September 4th, 1940, aged 65 or 66 years old. Edward Ned Callahan would die May 11, 1912, shot in his bed in Buckhorn, Perry County, Kentucky. He would die shortly after making a peace treaty with Captain Strong, who he was also feuding against. There is more information available about this in our Strong-Callahan feud video. Benjamin Fulton French was also of the French Eversole feud. He was shot in 1913 by Harry Clay, One-Arm Harry Eversole, when French met Joe Eversole's widow Susan and Harry on the street. French said, quote, "Good morning, Mrs. Eversole," unquote, when Eversole took out his pistol and shot French in the spleen. French would die of this wound in 1915. Jesse Spicer, also known as John McHenry Spicer. He was embroiled in a federal land case concerning fake land deeds. We found this article concerning the death of Jesse Spicer. According to the Find a Grave website, his real name was John McHenry Spicer. Born February 8, 1872, and died May 4, 1908. If true, he would have been the second of the feudists to die before the case was decided. According to the newspaper article on the site, there was a family quarrel over a potential divorce between Ed Callahan and his wife, who was sister to Jesse Spicer. Spicer and Callahan had an argument that came to blows when Spicer attacked Callahan with a knife and almost cut off his arm. Callahan's 17-year-old son, Wilson, came to his father's defense and shot Spicer through the heart, killing him instantly. And so ends the Bloody Breathitt County feuds. Thank you. We at Kentucky Tennessee Living would like to thank you for watching our video series on the Appalachian feuds. Don't forget to hit that like button, as the more likes we receive, the more likely YouTube is to suggest our videos to other viewers. Also, to receive notice when we upload a new video, be sure to subscribe and click the bell notification button. Be sure to double check that you are subscribed, as some of our viewers are finding that they are no longer subscribed to our channel. We thank you for continuing to support Kentucky Tennessee Living as we are discovering the mysteries in Appalachian history.